Thank you. Thank you kindly. All right, so the next matter on our list is 24P0181, Doe number 528140 versus the Sex Offender Registry Board.
May it please the court, Attorney Fred Burkholder for John Doe, 528140. Good afternoon.
Good afternoon.
So, my brief covers my argument. My brother and I were having some conversations before, and we may have narrowed the issue to the benefit of the court.
Any more narrow than extra-familial versus intrafamilial?
Well, even more narrow than that. Okay. And basically as follows. What you're going to hear from my brother, and I'm just prefacing it, I'm not trying to make his argument, is what you're going to hear from him is that an intrafamilial relationship isn't dependent solely upon the length of time in which someone is in the residence, but it also requires something more. Now, I don't see that in the regulations, nor do I see it in any of the case law. Then we got into a discussion of the case that both of us cited.
So aside from that, I just want to hear, what's your argument?
Well, my argument is the facts are very clear. I mean, both parties indicated that they were in a, I don't want to call it relationship, but they had been together for 3 years, and that they had lived together for...
Living together, right? Roommates for 3 years with intermittent intimacy.
I don't think
when you say they, do you think that there's something in the record that they both indicated that they were together as a couple for 3 years?
No.
Okay.
No, and I stopped you only because I don't even think they say one says we've lived together for a while.
Right.
And the other one says, I've got the quotes right here, and the other one says they've been assaulted by her roommate, and they've known each other for over 3 years and have been living together. So,
and they both agree that they had this on-again, off-again romantic relationship.
That as well, and that's part of where my brother's argument is going with it is that...
I want to hear your argument. I don't want you to comment on his right yet.
Okay.
I want to hear
well, my argument is that's not necessary because you don't have a romantic relationship with your brother-in-law, or you don't have a romantic relationship with someone else that falls within the criteria of an intrafamilial. I mean, according to the guidelines definition of a family member substitute, it's foster, step relatives, or any other family household live-in relationship. I see nothing in that definition that requires anything more than time. And the one case...
Familial household live-in relationship.
That's correct.
So the victim says they aren't in an official relationship. Why isn't that enough for the board to find that they're not in intrafamilial relationship? She's a roommate, they occasionally have sex, but she's not in an official relationship.
I think it's splitting hairs, to be perfectly honest with you.
Well, that's what lawyers do and what the board has to do in applying its factors, and the question is whether that was an unreasonable application of that fact.
If that's the way the court interprets it, then I have no argument. I mean, basically, because how do you define relationship? Do you define relationship as being intimate on a daily basis, a weekly basis, an occasional basis? I mean, without being flip, there are people that have been married that have sex once a year. So is that the criteria?
The board cites various articles in the regulation, Factor 7. What do those articles say about what's required for an intrafamilial relationship?
The ones that refer to Stat 99R require more, but that's not in evidence in this case.
Okay, so are there any of those articles cited in at the end of Factor 7 that describe what an intrafamilial relationship is, or for that matter, an extrafamilial relationship, in a way that supports your argument here?
I can't answer that because I didn't look at them in that great a detail because they weren't admitted specifically in this case, and I've attempted to use that argument in the past myself and been told unless they were admitted, they're not before the board, or not before the court.
Well, I mean, if an article is cited in the board's regs, Does it have to be admitted in evidence to be something that we can consider in looking at whether the board interpreted its regs reasonably?
No, but I'd love for that to be the law. If that's what the law is now, then that
Studies-
opens up the door to all those areas of argument for us that are previously not there because it said, well, that wasn't introduced.
And
Well,
that
if it
was
doesn't have
about
to-
studies that were cited in the board's regs?
I've had many an argument where I've tried to make that argument, and it's been said, because you didn't introduce that specifically, it's not part of the record, and therefore, that you can't rely upon the specifics that are
Well,
contained
that's a
in it.
little surprising to me, but
I'll give you an
I would
example.
be interested, I would be interested in knowing whether anything in the articles cited in support of Factor 7 bear on whether this is an intrafamilial or extrafamilial relationship.
Again, I
And I
didn't
know
look.
you can't make the argument now because you didn't read the articles, but if there's something there, I'd like to see it.
If you're
And I'll make the
suggesting
same
a Rule 16
suggestion
letter
to-
thereafter, I'm certainly willing to do that within, a reasonable period of time, 7 days, if the court would permit.
Did I hear you say that you've made this argument several times before, but the court wouldn't permit it?
Well, for instance, when you get
I
into.
hear you say that.
Well, because I've done it. I'll give you an example. One of the examples is when you're dealing with age, and you're
No,
dealing
I
with.
don't, I mean, in this context.
No, I haven't made it in this context, but if you don't want to hear what I was going to say, I won't.
I just wanted you to answer my question directly, and then you can tell me what you want to say.
Okay, no. No, I've not tried to do it in this criteria. And the other criteria, all I started to say was this: when you're dealing with age, the guidelines cut off at age 60, and they only say you can apply weight thereafter. One of the leading studies by, I can't remember which of, it might have been Hansen, it might have been one of the others, says at age 70, risk falls off to virtually nothing. And I've attempted in the past, because I oftentimes get the cases much after the hearing, so I don't have the opportunity to introduce the articles, and I've made the argument that, well, that's what the articles say, and I've been told flat out, that's not in evidence. So as a result of that, we're left with the regulations or that the board had the opportunity to evaluate those studies when they prepared the regulations, and as such, you're stuck with their interpretation.
Well, but did the Henson article that you were just referring to, was that one that was cited in the board's
Yes.
regulation?
Yes.
And a court upheld the board's decision that because it wasn't offered at the hearing, you couldn't rely on it?
Yes, and they say it in the context
Can you
of,
include that with your 16L letter if you have a decision that says that?
the decision doesn't say that specifically that I can recall, and I'll have to go, you have to go through a lot of cases, and I don't know if I can find it.
Well, I can't speak for my colleagues, but it strikes me as unreasonable that if the board is citing articles in its regulations, that people who are challenging the board's interpretation of the regulations can't cite those articles, even if they haven't been introduced as evidence at the hearing. So if you have a case, a decision that says that, I'd like to see it.
If I may say one more sentence, maybe it'll put it in context. What we hear, and I said this once, but I want to reiterate it, and that's the following. What we hear is those guidelines or those articles were put before the board, and the board then gave their interpretation of what those articles in fact mean, and therefore, because oftentimes I do introduce articles that were part of the original regulations, and I'm told the very same thing. The hearing examiner will say, I defer to the board's interpretation of that article.
Well, I think one can distinguish between a case where the regulation speaks directly to an issue and rejects one of the interpretations that's in an article, on the one hand, and there the hearing officer could say, look, the board considered this, they obviously read the article because they cited it, and they came out differently, and I'm bound by that. That's one situation. Another situation is where you've got to interpret a somewhat indefinite term like relationship or familial relationship, and you've got to interpret it in a way that furthers the purpose of the regulations and the statute, and the regulation just doesn't address the particular issue. So what is the most logical place to look in determining whether the board's interpretation is reasonable, other than at least starting with those articles?
I couldn't agree with you more.
Can I say, at the most
Yes.
basic level, perhaps, because I'm not sure I understand your argument, are you arguing that if, assuming for the moment they were roommates for 3 years and there's evidence of nothing more, that is covered by intrafamilial?
The way I read this, and the way I read the plain meaning, the requirement that we interpret the plain meaning, yes.
Yes,
Because
okay.
I don't see any additional requirement that says the degree of what in quote-unquote a relationship
Well, you gave an example,
is.
for example, of brother-in-law. Well, I mean, that, by definition, seems to me is a family member. So what you're arguing, though, is that we should, if not adopt, interpret, or it already says that roommates, for example, are intrafamilial, simple by virtue of living in the same domicile.
But this says foster, too. So that
No, I
takes the
understand.
familiar
That's what I'm
relationship
asking. Yep.
completely out of it.
Okay.
So, yes, that is my argument, is that just by nature of the fact that they're within, and I think it
You're saying a
goes,
foster child is like a roommate. Is that the,
I mean, it says foster. That's
Right.
all it says. So,
Right.
so I mean, here we are trying to interpret something that we don't know, and I agree with Justice Sachs. Certainly, I'll go back to that. I think where it comes into play is this, and why it's relevant to me really is the fact that it talks about size of victim pool when we're dealing with the major issue that I'm trying to get to, which is the need for dissemination and the efficacy of it. And if your victim pool and your preferred targets are only those that are within your home, well, no matter what you call them, and what degree or not degree of relationship, and you are limited to that. And some of the cases even talk about whether or not the offense occurred within the confines of the home, because that being important. So
If they're not if they're not in an official relationship, at least according to the victim, then would it be reasonable for the board to anticipate that Mr. Doe would be having other relationships outside of the apartment where they're roommates?
Is it reasonable to assume that? I mean, as far as just generally in life, I don't know why it wouldn't be.
Okay, then why wouldn't dissemination serve a purpose?
Because they didn't have any improper conduct, even alleged improper conduct with somebody on the outside.
But if
Their
the idea
victim
is,
pool was limited
if
to-
if the offender had only ever offended against people in a family relationship, then you could argue that the dissemination doesn't make sense or as much sense because the offender isn't targeting people outside the family or outside the household. But if you've got an offender for whom the victim says, oh, we're not in an official relationship, we have sex occasionally, and that's Mr. Doe's version as well, then why couldn't the board reasonably conclude that Mr. Doe may be having relationships with people outside the house as well, and therefore that dissemination serves to warn those people?
I understand the argument, I follow it, but that doesn't account for the other cases that say the offense occurred within the confines of the home and makes that an important factor.
Okay, well, if the victim and the offender met and they went to the offender's home and had sex and it was a one-night stand, then does the fact that it happened in the offender's home mean the board can't disseminate because there's no evidence he offends against anyone outside the home?
But that language doesn't appear in that context. It appears in the context of an evaluation of whether or not there is a need for dissemination, i.e., that's their victim pool. It's not you going to someone else's home, it's whether or not you have that pool available to you within your home. That's the one case that I do cite in here kind of takes it, explains it a little bit better, and that is the individual who's 70 years old and is confined to a nursing home, or not nursing home, but is homeless, and has no opportunity then to go into a setting where he may in fact have the opportunity to address his target pool, which was in fact intrafamilial in the home. And in that case, they said there was not enough evidence to establish efficacy of determination. That case is cited in my brief. So I think we're all approaching the issue from different ways, but there's bases for my argument. And now it's left for you, of course, to decide whether I'm wrong.
So just one question about the burden of proof. Who has the burden of proof? I understand you'll take the position, very reasonably so, well supported, that the board has the burden of proof to show risk of reoffense, degree of dangerousness, internet dissemination would serve a public safety purpose. But who has the burden of proof on whether a victim is intrafamilial, extra-familial, or stranger?
My argument is it's a subsidiary fact, and they have the burden by preponderance of the evidence.
If they don't prove anything about the status of the victim, what's the default? Do we assume that the victim is intrafamilial?
No evidence, so how can you make a decision without evidence?
Well, so what?
They can't apply the factor. And interesting.
Okay, so then could you argue that there was no evidence about the status of the victim, so therefore the board must treat?
Yes, and I go all the way back to Cobble, one of the very original cases.
I'm not speaking, but I don't know what the question is.
The question is, what is the default if there's no evidence regarding the status of the victim?
Then they can't apply the factor. I go back to the language of Cobble, which said, and this is way back in our known, which were cases back in 1997 and then cited in 1999, and it says the court's approach is one of judicial deference and restraint, but not abdication. Judicial deference ceases to apply where, I'm only one more sentence, where we conclude the agency has failed to adhere to its own statutory mandate and regulatory framework by making a decision without sufficient evidentiary support.
All right, so if they can't apply the factor, that's your...
It's my argument. That's what the case law says.
Okay. Thank you.
See, that's your time. Thank you kindly.
Thank you, Your Honor.
Nicola.
I think we're still in the morning, or no, just afternoon now. Good afternoon, Your Honors. Stephen Killalay on behalf of the Appellee Sex Offender Registry Board. May it please the Court. I want to just start by saying that the matter turns on the substantial evidence supporting the hearing examiner's decision to classify Doe as a level 2 sex offender, where Doe assaulted with intent to rape an extra-familial victim within a shared living space. Now, there were questions to my brother about the specific facts in this case, and I believe Justice Brennan asked, well, here they were living together for 3 years. There's nothing to suggest in the record that they lived together for 3 years. In fact, there's only evidence in the record that they knew each other for approximately 3 years. That was stated by both the victim of the index offense as well as by Doe when he had a conversation with police. What's very clear in the hearing examiner's decision is that he understood that. The hearing examiner understood that the length of time was 3 years with which they knew each other. Then now what we have to boil that down to is, was it a reasonable finding for him to say, well, the nature of the relationship, again, the statute calls the hearing examiner and the board to consider the nature of the relationship, the scope of the relationship. Now, there were some questions about, well, where does Factor 7 come from, the research underlying that factor? Well, the predominant research and guiding principles regarding underlying Factor 7 come from the Static 99 coding rules. And essentially, if you look at the Static 99 coding rules, they essentially mimic the language of Factor 7. Because again, you're talking about a discretionary risk assessment tool being used by clinicians in that particular setting to make a risk assessment, and it's very important to understand the nature of the relationship between the offender and their victim. Why? Well, because as we are talking about here, if it's an intrafamilial victim, it's shown that there's a less risk of reoffense. But if there is an extrafamilial victim or stranger victim, then that then that increases the risk of reoffense. So, what does the hearing examiner do here? He considers the evidence before him. He considers the reliable hearsay statements that are within the police report. At no point in time does the alleged victim or the victim of the index offense describe their relationship as anything other than roommates. In fact, Doe never describes the relationship as anything but roommates. Now, conceitedly, they do have intimate moments together. Now, the question is, does having intimate moments together transform the relationship into a familial one? I would submit to you that it does not.
I know you responded to it in your brief, but could you address the issue about the restraining order? the order that involves, by definition at least, a household or family member?
Sure. So one of my brother's arguments is that the court should look to the fact that the Doe was also charged with assault and battery on a family or household member, and he essentially looks to the definition within that statute as evidence of what the nature of the relationship is. And the problem with that argument, as pointed out in my response here, is that I think that Doe 185989 is a Rule 23 decision, so obviously it's not binding on this panel, but I think it's persuasive here, is that in the context of 209A, they rejected that argument. They essentially say, no, what the board is responsible for doing is looking at the nature of the relationship. Again, that's what the statute calls us to do. Now, the guiding principles are provided within the confines of Factor 7, and I would suggest to you that the hearing examiner did that here. He didn't look to what assault and battery on a family household member would define the relationship as. He looked to the record before him, he looked to the evidence that was there, and he specifically, while not explicitly state that he didn't find it to be a family member substitute, it's certainly implied in his analysis under Factor 7 and in his summary discussion within the confines of the decision. He essentially states, these are individuals who lived together for a while and knew each other for 3 years. And he specifically states, they are roommates. I would submit that given that finding, that they are roommates, and they are not family member substitutes, that it is reasonable, it's articulated, and that deference should be owed in that finding. And I would urge you to find that there was no error. Now, I think that when you take that into consideration, so application of Factor 7, and given the fact that this petitioner, in the eyes of the board, committed assault with intent to commit rape, which is a very significant crime. It's a crime which the legislator has defined to be a sexually violent offense. And given essentially the level of violence used, not only on one occasion, but multiple attempts to essentially commit a rape. I mean, this is an individual that was consuming alcohol. When he was refused sex, he essentially demanded it. He was going to get it. He tried on numerous occasions within the span of the offense to essentially make that happen, and it was really only through the determination of the victim not wanting to have sex that didn't occur. So let's take that into the last argument, is that, well, this is precisely the kind of case where the efficacy of internet publication makes sense, right? Because you have essentially a victim who was a roommate of this individual, who consumed alcohol with him, and essentially denied him a sexual encounter. Well, when that happened, he responded with violence, he responded with speed, he responded with the kind of situation that acquaintances, friends, other roommates, presumably that he may have in the future, should have access to that information and should be warned via the internet publication. And if there's no further questions, I would rest on my brief.
I would like to ask, where the regulation uses a term but doesn't clearly define it, and it's subject to some reasonable disagreement, like family member substitute or familial household live-in relationship, is it appropriate to look to the articles that the board cites in the regulation to see if they shed any light on how that term should be interpreted?
I'm unfamiliar with any limitation that would prevent that. Moreover, I think that the hearing examiner, as in all cases, takes administrative notice not only of the regulations, and by virtue of that, I think understands that opens the board's interpretation. Essentially, I think the underlying documents would be subsumed within the record itself. And I think that Your Honor's brought up an interesting point when you talked about that with my brother counsel, is that I think there's a distinction to be made. To the extent that somebody may be looking to the underlying research that's being offered in an appeal and then says that the board took a interpretation that was inconsistent with that, well, then that's something that probably should be raised at the hearing, should be raised obviously at the Superior Court level, and then obviously will be properly before Your Honors to make that clear distinction. But in a sense of if the court is grappling with a reasonable interpretation of the existing statute, then I certainly think you have to look to the underlying research and or documentation the board has utilized, Your Honors. With that, I would rest on my brief.
Thank you, Counsel.
Thank you.
Matter stands submitted. Our final matter for the afternoon is 24P0226, Doe number 5266715 versus the Sex Offender Registry Board. Attorney Nearing, when you're ready.
May it please the panel, my name is Ilse Nearing, and I represent Doe. In sum, the classification must be vacated for 3 reasons. First, the findings that Doe suffered from quote-unquote potential deviant sexual interest in minor females, and that his alleged behavior was quote-unquote in line with grooming, was unsupported by substantial evidence and was an unqualified opinion because the factors did not authorize the hearing examiner to make independent findings about Doe's psychological conditions or issues, such as potential deviant sexual interest, or that his behavior was in line with a psychological construct, for example, grooming.
So, factually, let's just talk about factually. It appears that Doe, at one point, worked as a counselor at a troubled teen center. I'll call it a center. Is that correct?
There is no what? I beg your pardon?
That Doe, at one point, was a counselor at a troubled teen. I refer to it as a center. Is that correct?
I can't hear you, actually. There is no what?
Was Doe a counselor at a troubled teen center at one point?
In 2005.
You understand that question?
Okay, in 2005, there was no...
Was Doe a counselor at a troubled teen center? Was he a counselor? Do you understand that question?
A counsel.
Counselor.
Did he have a counselor?
No, was he a counselor?
I only understood that he, I beg your pardon, my understanding is that Doe worked the night shift and that he was simply there to check the rooms every 10 minutes, wake them up in the morning, and I don't know what time the night shift started.
What capacity did he work there? How would you characterize the capacity that he worked there?
How would I characterize his what?
What capacity he worked there? What was his title?
Was he a
The
custodian?
record doesn't
or
have
was
a
he-
title, to my knowledge.
Right. He had some responsibility for directly supervising the residents, the underage residents. Would you agree with that?
From my reading of the record, his job entailed sitting in a hallway, sitting in front of the girl named A's door because she was a runner. His job entailed checking the beds every 10 minutes of all 6 girls to make sure they were in the beds.
Okay, so we're not trying to be difficult here. He had a direct supervision role over teenage girls. I mean, that's just the predicate for the question. I don't think it's controversial.
Yes, he had to observe and monitor that they were in their beds and sit in front of the door to make sure that the girl didn't leave. Yes.
Did he have any obligation while he worked there to report if he had any extended conversations with any of the residents, any of the teen residents?
Yes, there is a statement in the record that he had such an obligation, and that...
And in his role as a monitor, I think you called him essentially a hall monitor, it sounded like. In his role as a hall monitor, was he permitted to develop personal relationships with the residents?
I don't know whether or not he was permitted to develop personal relationships, but I would not characterize what I read in the record as a personal relationship.
Okay.
He did not describe it that way either.
My understanding was, at least from what I read, that at some points he would go into her room in the early morning hours and sit and talk to her and listen to her troubles and concerns for 30 minutes, 45 minutes. Is that accurate?
With one minor detail, my understanding of the record is that she and her friend came out into the hallway from their room and they spoke their rooms, and they spoke to him in the hallway. In a hallway.
He never went into her room and in your view is he never went into her room and had any conversations with her while she was still in bed or tried to wake her up or any of those things. Is that what I hear you say?
So the facts of the case alleged that at 3 o'clock in the morning, Doe went into her bedroom and woke her up and asked for a pillow or asked her to leave a pillow in the hallway.
That consistent with being a hall monitor?
And that he denied in his response that he did that.
Right, and
Thank you. Sorry, go ahead.
of course, they didn't have to credit, it was up for the hearing person to determine who they believed, right?
The DCF investigator had a summary of what facts were based upon their findings, and that particular fact of allegedly going into the bedroom at 3 a.m. in the morning and asking for a pillow, I don't believe that that was one of the facts that DCF alleged was supporting their finding.
Can I just ask, I'm sorry, just on that question, just to clarify that, because her version was not that, you seem to suggest it happened once, but I'm reading it and it says she stated that it happened a lot of times. Is that, I mean, whether you agree with that or not, that's what it says.
Then
Yes?
I beg the court's pardon because I've made a
missed it?
mistake. I missed that in the record, that she
Okay.
said it occurred then more than
Yep.
one occasion.
I'm just reading.
Please,
The
I
girl
beg your
stated the
pardon.
plaintiff would come into a room at 3 o'clock in the morning, wake her up, use one of her pillows, and he did this a lot of times. I just want to make sure that we're on the same page. And if you disagree that that's what it is, that's fine. I just wanted to just,
I don't remember reading that, and
Okay.
so I'm not trying to hide a fact.
Oh, no, fair.
I don't
No,
know
problem.
right now,
Sorry to
Your Honor.
interrupt you.
That's okay. At the end of the day, he was terminated from that position as a result of this alleged conduct. Is that fair to say?
Yes?
So when you say grooming, and you take issue with the term grooming, correct? Is that what I hear you saying?
I take issue with the word room.
With the word grooming, that he was grooming
Oh, yes.
these victims.
Grooming. Okay, so first of all, the factors do not authorize a hearing examiner to make independent findings based on facts alleged in hearsay that the board determined or deemed to be credible and reliable, that Doe's behavior was in line with grooming. And the factors also did not state that grooming was germane to recidivism and dangerousness. And in Commonwealth versus Christie, the appeals court recognized that there is no single legal definition for grooming. And Christie established that grooming is a psychological issue and construct because in Christie's facts, it indicated that the testimony of a mental health expert defined grooming and also explained how the defendant's alleged facts conformed with that definition.
May I ask you a question? I just want to make sure we're on the same page because, and then I'll leave it, at least for me. Because when you described him as just sort of a guy who sits out in the hallway in more of a monitor role, again, I just want to make sure, are you disagreeing that the child said that he would rub her stomach and her back, that he came in when she was in the shower, that he said, I have something to show you, knowing that she was in the shower, things of that sort, which don't seem to me at least to fit into the hall monitor, strictly sitting by and make sure kids don't run type of a role?
Well, my reading of the record is that she alleged that when he went into her room in the morning to wake her up, he touched her stomach and her back over the covers. Also, she alleged that he knocked on the door when she was in the bathroom or the shower. He said that he knocked on the door to give the residents their morning medications.
Okay.
So the medication story or knocking on the bathroom door did not end up in either the hearing examiner's decision or in the DCF conclusion.
Okay, sorry.
But there were other comments that she alleged that did end up in there, right? Didn't she allege that he had made a comment to her about the pleasure he received in folding her red cherry-colored thongs, for one. That ended up in the record, right?
So,
He denied that.
well, yeah, he denied that. But about all these facts alleged in the DCF report, so it's the board's burden to establish by a preponderance that Doe committed sexual misconduct, and on April 25th, the board is going to promulgate a regulation that defines sexual misconduct as allegations of illegal or non-consensual sexual conduct. The ordinary meaning of sexual is having sex and involving sex. The other thing I'd like to say is that Doe 205614.
Sorry, I just need to stop you there. Involving sex. You don't think that the conduct here alleged in 2005 involved sex in the sense that he was making sexualized comments about her and touching her?
I don't think
The board
that
couldn't reasonably conclude that?
I don't think it's, she perceived, first of all, he denied it all, but just because she perceived it as his making sexual advances does not mean the facts taken together constitute conduct that is involving sex or having sex, or that it is illegal sexual conduct.
Are we to take anything from the, if the hearing examiner credited her testimony, and I believe that there was some other witnesses to some of that conduct that corroborated her views, if that's the case, how should we view his denials in trying to distance himself from that activity?
About his denials, I think what is helpful is the case law that says the sexual impetus behind an offense should not be assumed, where the offender's overt acts do not evidence the offender's sexual desires or sexual gratification. And that's exactly the framework how one views his denials. Not only didn't happen,
can I just-
none of this was for sexual gratification or desire.
Can we, on that issue, can we, in your view, look at what he did later to contextualize, or could the examiner look at what he did later to contextualize his behavior and comments from years before? Or must we look at each incident in isolation, or must I say the examiner?
Honestly, the unpublished opinions of this court do say that subsequent conduct can be used to corroborate prior conduct.
Right. Or what, in isolation, what he may have said to the kid years ago may be interpreted two ways, but then if you look and accept his behavior later, that might inform, at least for the examiner, what that really was meant, and whether it was sexualized or just an offhanded comment in some way. Is that fair? Without turning it into grooming.
I sort of see it more as it's a kind of where there's smoke, there's fire.
Okay.
So at bottom, one of the concerns was that here you have somebody who has a significant age gap between the victim and himself. I think the first incident in 2005, he was, 24 or something, and she was 15 or 16, I forget exactly. And then subsequently, the next incident, 12 years later, he was, I forget, 12 years later, 36, and the victim at that time was 15 or 16. In both instances, he seemed to have this position of trust in that one was a teen trouble center, and in the second incident, 12 years later, he was the travel basketball coach for the victim. And in those positions, the hearing examiner considered that relationship between the offender or the alleged offender and the victims. Would you say that that's fair?
Yes, it is fair. It is not it's not my argument.
Okay.
So I see I have 14 seconds.
That's all right,
So
go
if
ahead.
there are no further questions, I will be seated.
May I ask, did you include the draft regulation? Yes, you did, I see, in 38 of
I
your
did in my reply brief, Your
Got it.
Honor.
Thank you.
Thanks.
Thank you.
If it pleases the court, David Chennai for the board. I wanted to let you know that this morning at 6 o'clock in the morning, I drove through a snowstorm on top of Florida Mountain to get here. But I am here, and the board's position is that the evidence, substantial evidence proves in 2005, he did commit acts of sexual misconduct against this, at that time, 15-year-old girl.
So let me ask you this, Attorney Chennai. The board relies on 2 high-risk factors and 6 risk-elevating factors, correct?
Correct.
And you can see that of the 6 risk-elevating factors, 2 of them were misapplied. So that's a third of them, right?
Correct.
So with that, why shouldn't we remand it and see if he should get a different result?
You know, I've given this some thought. I also think that you have to look at the behavior in this case. If this individual committed one sex offense in 2005, I think that's a stronger argument. What we're arguing is it's more of a harmless error situation in the sense that he did the same exact acts 13 years later, and those acts were in 2018. And he was convicted of rape of a child in 2018 against a 14-year-old girl.
But an important factor here was factor 2. And if you take the 2005 conduct out of the picture, then you can't apply factor 2.
This is correct, but we're not conceding that factor 2 doesn't apply.
I understand
because-
you're not conceding that, but the question isn't whether the evidence would be sufficient to uphold the board's decision, even if we disregarded certain factors, but whether it is certain that the board would have reached the same result. Because if the offender's rights may have been prejudiced, then we're supposed to remand, aren't we?
Well, I look at it this way. If you accept the fact that in 2005, he committed acts of sexual misconduct against that girl, and if you also agree that in 2018 he committed a sex offense, then factor 2 is applicable. And factor 2 goes a long way in determining someone's risk and danger, especially someone whose second sex offense occurred when he was 36 years old after he'd been investigated for sexual misconduct. He then commits the second sex offense against a 14-year-old girl using the same grooming methods he tried to use in 2005. Therefore, the board's position, if you accept the fact that these events occurred and that they are indeed sex offenses, having whether or not factor 8 or I believe it was the second factor 16, their applicability, I don't think that indicates or lessens or reduces the individual's current risk because of the recency of the second sex offending behavior, the fact that it was a child, the fact that it was exactly the same pattern he tried to use in 2005 to groom a child. I mean, he goes to a woman that he knows, convinces her to let her daughter be on his travel basketball team, and then grooms that child so that then he has complete access to the child. And it's even kind of more bizarre, he starts controlling her life. The whole incident with the cell phone is clear that what he was doing was manipulating her and controlling her. The fact that she talked to another teenage boy enraged him. He goes to her house when her mother's not home, goes up to her room, trashes her room, grabs her cell phone and takes it.
Well,
that goes beyond.
I don't know that anyone's disputing that there's cause for concern about this offender's conduct. The question before us really is whether the board considered the factors properly. So I want to ask about a couple other factors. So, substance abuse. One place the hearing officer says she gives it minimal weight. In another place, she gives it increased weight. So doesn't that kind of raise a question?
Well, I did see that myself, and I have a feeling that the second level was probably either a cut and paste issue or a misspelling.
Yeah.
because I think factor 10, when she applied it, was very clear. The reasons why she gave it minimal weight is because of his not appearing to have a substance abuse issue currently. So I think that she clearly had found that it was minimal. Now, I know it was written in the risk, when she was discussing risk to reoffend. And again, that's something you're going to have to decide whether or not that's a harmless error also. Now, you may find that having 3 of these issues in one decision is problematic. Again, having looked at all of the evidence, the board's position is that it's still harmless because of the type of behavior involved here.
Well, let me ask you about a 4th before we come to the final reckoning. The treatment of the empirically based risk assessment instruments. I couldn't understand what weight the hearing examiner was giving to them. She says she gives them some weight to the extent they were correctly applied. And in so doing, only to the extent that they may be seen as general indicators of a risk of reoffense. So I can't tell what the hearing examiner is doing there.
What she's doing is she's saying, there are these tests, I have to look at them under Regulation 35, but she's not giving them a whole lot of weight. The only thing in there is she looks at those actuarial tables, and I think she also looks at the PPG testing. But she's basically saying those test results, they may be general indicators of risk, but she also is talking about the fact that the board's regulations and their application is more
We see that
beneficial
in
to
board, in hearing examiner decisions all the time, but what we don't necessarily see is raising a question about whether the instruments were properly applied and then kind of shrugging it off. She gives the tests some weight to the extent they were correctly applied, but she doesn't make a determination about whether they were correctly applied.
Well, I think,
And I saw, maybe the biggest question raised by the record in that regard was on the PPG. Due to no significant arousal to deviant stimuli, Doe's data was not appropriate for statistical analysis for sexual preferences. Does that call into question the result of the PPG, which was completely normal as far as I can see?
it does in the sense that his behavior with, in the past with teenage girls, clearly indicates there's a deviance there of some sort. So the PPG testing, which I think doesn't always is as accurate as everybody believes it to be, and I think there's been some issues in some of the Supreme Court decisions about the PPG and its applicability. But at the same time, I think because there was no statistical analysis giving to actual sexual preferences, and this issue in this case was, is his sexual preference teenage girls, his actions speak louder than the testing results.
Well, it would be one thing to say, I recognize the PPG result, but that doesn't persuade me that he doesn't prefer underage teenage girls. It's another to say, I have a question about whether the PPG was even properly applied. And a question, it's one thing to balance the different factors, but it seems like another to say, hey, I'm not even sure that this test was properly applied, so I don't even need to balance it.
Well, I think that the hearing examiner is making a factual determination on the fact that the test results said that there was no stimuli to deviant behavior, even though he has a history of deviant behavior. And I think the hearing examiner...
But might the no response to deviant stimuli indicate that he's got those prior impulses under control? Just as, can a lay hearing examiner draw an inference that because he didn't respond to those stimuli, it must be because there's some problem in the way the test is administered?
Well, I think what the hearing examiner is trying to say is that the test results indicated that there was statistically that could not give you the preferences, his sexual preferences. So I think what the hearing examiner is trying to say is, but the evidence shows he does have a sexual preference, and therefore the PPG testing may not be accurate in this matter.
PPG testing given here any different than any other PPG testing? I have to assume that a sufficient number of stimuli in each of the categories is presented to the offender to allow some kind of statistically valid conclusion. Otherwise, the PPG wouldn't have gotten as far as it has, even though it's been questioned. So there's no evidence that the PPG wasn't administered as is supposed to be.
Correct.
And so when it doesn't show a response to deviant stimuli, how can the examiner say, well, it must not have been properly administered?
I think the hearing examiner probably shouldn't have wrote that. I think the issue is really, it was the issue of that it didn't show a sexual preference when he has a history of sexual preferences. So I think that that's where the hearing examiner was falling on that issue.
Did the hearing examiner credit, say, to the extent that it was applied correctly, she credited it, or did she discredit it in the end?
I don't think she credited or discredited. I think what she said is that the results, because they could not determine the sexual preference because of the statistical analysis, I think what she was saying is the test result flies in the face of his behaviors as early as 2018, this test being given 1 year, less than 1 year after his sex offending behavior.
So therefore what?
Therefore, the hearing examiner was trying to point out that he does have a sexual preference to teenage girls.
No, therefore what with respect to the PPG?
Therefore, with respect to the PPG, I think she disregarded the PPG
That's
findings.
discrediting it, right?
Well, discredited,
That we started there.
I think it's, 6 of one, half a dozen of the other, but in the end, you're
That's four
probably
things
right.
now. So now we're up to four. So now we're up to four things.
And again, I think what you have to weigh out is the 4 factors or the 4 issues that you have with the offender's behavior and whether or not remanding it back to the board would change the end result. Was he prejudiced to the point where it would result in a lowered classification or a possible lowered classification? I think that would be DOE 22188. I think the board's position is no, that it's pretty clear, the remaining evidence is pretty strong that if you remand this matter back, based on the evidence that was presented to the hearing examiner at the year that it was given to the hearing examiner, he's still a 3.
So there's no way he could be a 2.
I don't think so based on the facts. Again, if the second sex offense happened 10 years ago, I'd say we've got an issue here, but it was so recent. I mean, he got a 5-year sentence in 2018, so he was still incarcerated at the treatment center at the time of the classification hearing. Again, I think you have to look at the timing of this to determine whether or not he would be lowered. Again, if this was 10 years ago and you could say these mistakes were really prejudicial, the second one was a pretty recent, pretty egregious sex offense, and I think that really weighs heavily, especially with factor 2 being strongly in this case. So unless the court has any other questions, I believe I've handled these questions the best I can in my brief.
When would he be permitted to have another evaluation?
I'm trying to remember when the decision was. I think it was 2022 maybe, or maybe 23. So I'm guessing he would have it in, I think I was thinking it was this summer, but it might be next summer. But it's 3 years after the actual date. And believe it or not, I knew the date coming in here, and I just popped out of my head. Age is catching up to me.
Blame it on the snow. Stressful ride in, how's that?
I see you have 1:25 left. Anything additionally?
Excuse me?
I see you have 1:20 left. Anything additionally?
No, I always like to get out while I'm still standing. Thank you.
Stand submitted. Thank you both. That concludes our business for the day. The court stands in recess. Many thanks to everybody who helped run the session today, the court officers, our time clerk. Thank you very much.